In another video, I talked about what a Court of Appeals does and what a Court of Appeals can review. And we talked about the fact that a court can't review whether or not there was evidence to support a conviction except in extremely rare situations. The shorthand way to look at it, or the easy way to look at it, is that the Court of Appeals is not going to review the jury decision. They're not looking at a case to see whether the jury got it right or not. They do review impact and what impact evidence may have had on a jury in limited exceptions, but they're not reviewing the actual decision. Instead, they're reviewing the trial court and what the trial court did. And basically they're grading the paper of the trial judge. In any case, there are things that happen during trial and before trial. There may be motions filed, such as motions to suppress, motions to limit evidence, motions to exclude evidence. At trials, there are going to be objections made to testimony or to certain evidence, and the judge has to rule on all those things. The purpose of the appeal is for the Court of Appeals to review those decisions and determine whether they were accurate or not. And that's what you look at in an appeal. You review the objections that were made, the motions that were filed. Basically, any decision that a trial judge makes during the course of a trial can be reviewed on appeal. So that means that there are some important limitations on what the Court of Appeals can and can't do. They can review the decisions that the trial judge makes, but they can't review decisions that he or she is never asked to make. For example, there are also often claims or complaints about evidence not being presented, witnesses not being presented, questions not being asked. A court can't review any of those things because the Court of Appeals decision is limited to the record. And the record in an appeal is basically the transcript of what occurred during the trial. That's a written record of all the questions and the answers and the arguments. And that's what the Court of Appeals is limited to. They're bound by that particular document. Anything that's not contained in that document is not something they can consider. And so if there aren't any objections, if there aren't any issues, if their trial was what is sometimes referred as pretty clean, where the trial judge didn't really have to step in and make a lot of decisions, there aren't going to be very many issues that can be raised on appeal.